You go to work every single day thinking you're safe. But what happens when one ignored rule can cost a worker their life, destroy a billion-dollar company, and send the owner straight to prison? Stay until the end, because the last revelation in this video is going to leave you speechless. Before you keep watching, do this right now. Hit the like button. Not later. Right now. Because this video is going to blow your mind and you're going to want everyone you know to see it. Done? Great. Let's go. There is an organization in the United States that has the power to walk into your company without warning, shut down your entire operation, seize machines that cost millions, issue fines that reach $165,000 per violation, per day, and still not have the authority to permanently close you down. But you know what happens when they can't shut you down? The fines keep growing. Every single day of delay, another $16,550 gone. This organization is called OSHA, the Occupational Safety and Health Administration, and it is, without exaggeration, the single biggest corporate terror in the United States. And the most shocking part of all? The majority of American workers have absolutely no idea what rights they actually have inside their own workplace. That is what we're changing today. Hello everyone, I'm Eric, the workplace safety guy, and I'm going to tell you how this machine works from the inside, what the most insane rules are, which companies were destroyed for ignoring them, and most importantly, what right workers have that almost no boss ever wants you to know about. And I guarantee that at least one thing in this video will permanently change the way you see your own job. OSHA was born in 1970, signed into law by President Richard Nixon, after decades in which American workers were dying at an industrial pace with virtually no meaningful legal protection. Before that, workplace accidents were practically considered part of doing business. Mining companies lost workers buried alive. Factories lost operators to unguarded machines. Construction sites killed workers every single week like it was normal. And then the federal government finally said, enough. And it created the most powerful occupational safety entity the world had ever seen. Since then, more than 50 years later, workplace deaths have dropped dramatically, but the numbers are still terrifying. In 2022, according to the Bureau of Labor Statistics, 5,486 people died in workplace accidents in the United States alone. And more than 2.8 million non-fatal injuries and occupational illnesses were recorded. 2.8 million in a single year. Let that sink in. Now think about this. If there are still 5,000 deaths per year with all this enforcement in place, what would it look like without it? The answer is simple and terrifying. It would be so much worse. And that is exactly why OSHA keeps issuing record fines, conducting surprise inspections, and placing entire companies into what they call the Severe Violator Enforcement Program, the program for the worst offenders. Getting on that list is basically a corporate nightmare. Because from that point on, the scrutiny never stops. Ever. But let's get to what really matters. Let's talk about the rules. And the first one, which has been the most violated standard in the United States for the 14th consecutive year, is fall protection. 14 years straight at the top of the list. That is not a coincidence. In 2024, there were 6,307 violations recorded in this category alone. 6,307. And do you know why? Because falls are the leading cause of death in the construction industry. In 2022, 865 workers died from falls on the job in the United States. 865 people who left home to go to work and never came back because someone decided that a safety harness, a lifeline, and a guardrail were overkill. They weren't. And when OSHA shows up after the accident, the company finds out the hard way just how much cheaper that overkill would have been compared to the multimillion-dollar fine that follows. The fall protection rule in the United States leaves absolutely no room for interpretation. Every worker exposed to a fall risk above 6 feet in construction needs active protection. That is not a suggestion. It is federal law. And when that law is ignored and a worker dies, OSHA will not simply fine the company. Starting in 2024, the partnership between OSHA and the Department of Justice was formally strengthened to aggressively increase criminal referrals in these cases. Meaning, the company owner can go to prison. That is not a figure of speech. It is the legal path the American government has started pursuing far more frequently in recent years. But wait, because there is something far worse than fall protection violations. There is a rule that makes engineers lose sleep. A standard that was born after workers literally died inside machines during routine maintenance. I'm talking about lockout/tagout, or simply LOTO. In 2024, There were 2,443 violations of this standard, an 11% jump from the year before. And do you know what LOTO requires? That before any maintenance on any machine, it must be completely shut down, isolated from every energy source, electrical, mechanical, hydraulic, chemical, whatever it may be, physically locked with a padlock and tagged so that no one can accidentally restart it while someone is inside. Sounds obvious, right? But lockout/tagout is the 5th most violated standard in the United States. And the consequences when it is ignored are unbelievable. In 2022, workers were caught in running equipment during maintenance 54 times in situations that resulted in death. 54 times. And nearly 18,000 cases resulted in days away from work or restricted activity in the same period. 18,000 people who could have come home in one piece. Now let me tell you something that will completely change the way you think about corporate fines in the United States. There is no maximum cap on total accumulated fines for most cases. There is a per violation ceiling, $16,550 for serious violations, $165,514 for willful or repeat violations in 2025. But if the company ignores the notification and fails to correct the problem within the established deadline, the fine starts running daily. Every day. $16,550 per day. Do the math. 30 days of delay equals nearly $500,000 in penalties, on top of the original citation. And that doesn't even count lawsuits, victim family settlements, lost contracts, and destroyed reputation. A company that ignores a correction deadline can watch $500,000 evaporate in a single month. And still, some employers choose to stay in the dark. And that is exactly where the most feared clause in all of American labor law comes in. The General Duty Clause. This is OSHA's nuclear weapon. It sits in Section 5A1 of the OSHA Act and states, in plain language, that every employer has the obligation to provide their employees with a workplace free from recognized hazards that are likely to cause death or serious physical harm. Notice the word, recognized. There doesn't need to be a specific rule prohibiting that hazard. It just needs to be recognizable by any reasonable person. This means that if OSHA can prove the company knew about the risk, or should have known, and did nothing, it can apply the General Duty Clause even without a specific violated regulation. There is virtually no escape. It's like a regulatory black hole. Once you're inside the gravitational field, it's over. And now comes the part no boss ever wants you to know. The right that American workers have that can change everything. You, as a worker in the United States, have the legal right to refuse a task if you reasonably believe it poses an imminent danger of death or serious injury. It can't be just any reason. It has to be serious. But when it is, you can say no, without being fired for it. Federal law prohibits retaliation against workers who exercise this right. If the company fires you, demotes you, or retaliates against you for refusing dangerous work or reporting a hazard to OSHA, the company can be sued. And the consequences include reinstatement, payment of back wages with interest, compensation for emotional distress, and even punitive damages, the American Punitive Damages System, which is calculated not just to compensate the victim, but to punish the company in an exemplary way. And there's more. You have the right to request an OSHA inspection completely anonymously. The company doesn't need to know it was you. And the deadline to file a retaliation complaint after suffering reprisal is just 30 days. So if this happens to you or someone you know, the clock is ticking. 30 days. Don't miss that deadline. Now let me show you what happens when a company decides to ignore all of this in practice. Take Dollar Tree. In June 2025, OSHA fined Dollar Tree in Alexandria, Virginia, $284,225. Why? For failing to keep emergency exit routes clear. For citations, all repeat violations, which automatically raises the maximum fine threshold. A billion-dollar retail chain with stores spread across the entire country, taking nearly $300,000 in fines because emergency exits were blocked. It wasn't explosive material. It wasn't a deadly chemical. It was simply the path people would need to take to escape a fire. And the company failed at that not once, but repeatedly. This is what defines an intentional violation in OSHA's view. It's not necessarily malice. It's indifference. And indifference carries an extremely high price tag in the United States. You want to know what's worse than a $284,000 fine? being placed in the Severe Violator Enforcement Program. This OSHA blacklist is reserved for companies that consistently demonstrate total disregard for their legal safety obligations. When a company enters this program, the scrutiny never stops. Recurring inspections, intense monitoring, maximum public visibility. It's basically a dangerous company stamp that any business partner, investor, or customer can see. And getting out of this program is neither simple nor fast. Some companies spend years under this level of scrutiny while trying to prove they've changed. But now I need to explain something that most people never stop to think about: how an OSHA inspection actually works from the inside. Because it's not the way you imagine. It's not a form sent in advance. It's not an email giving notice. It's not a phone call to schedule a time. It is a knock at the door. Literally. And by law, OSHA inspectors are prohibited from giving advance notice. This is not an informal practice, it is a legal prohibition. Because if companies knew the inspection was coming, what would happen? Exactly what you're thinking. Helmets would appear out of nowhere. Machines would be shut down in a rush. Unlabeled chemicals would be hidden. Emergency exits would be cleared in minutes. And the inspector would find a fake, cleaned-up version of reality, not what actually happens every single day when no one is watching. That's why the surprise is the essence of the system. And that's why it terrifies companies so much. In 2024, OSHA conducted 34,625 inspections in total. Of those, 17,455 were called unprogrammed inspections, the ones that arrive without warning, triggered by an employee complaint, a serious accident, a fatality, or a referral from another government agency. The other 17,170 were programmed inspections, planned based on risk criteria, targeting high-hazard industries or companies with poor safety records. But even programmed inspections don't announce the exact day. And both arrive the same way. An inspector knocks on the door, presents credentials with a photo and serial number, and the inspection begins. Simple as that. No ceremony. And now comes the detail that's going to surprise you. The company has the right to demand a judicial warrant before letting the inspector in. This right exists because the Fourth Amendment of the U.S. Constitution protects against searches and inspections without judicial authorization. But in practice, the vast majority of companies never exercise this right. And the reason is disturbing. Studies and legal experts indicate that employers who demand a warrant before entry tend to receive more citations and higher fines than those who cooperate immediately. Because demanding a warrant creates an adversarial atmosphere from the very first second. The inspector notes that. And when they return, warrant in hand, they arrive with a completely different mindset. Furthermore, the time spent obtaining the warrant allows OSHA to issue an administrative subpoena for records before even physically entering the premises. Meaning, you delayed the physical entry, but your records are already heading to the inspector's desk anyway. Most American labor attorneys recommend cooperating and reserving the warrant strategy only for very specific situations where there are solid legal reasons to do so. So the inspection begins. And it has three very well-defined phases that every manager should know, but that most only discover when it's already too late. The first is the opening conference. The inspector sits down with a company representative, explains the reason for the inspection, describes the scope, presents which standards are being evaluated, and outlines the procedures that will be followed. It sounds formal and organized. And it is. But while the inspector is talking, they are already observing the state of the room, the behavior of the people present, the organization of documents, the demeanor of leadership. All of that is part of the assessment. A nervous representative who deflects direct questions or tries to restrict access without clear reason is already sending a signal. And the inspector is trained to pick up exactly those signals. After the conference comes the walk around, the physical tour of the facility. And this is where managers' hearts stop. The inspector walks through the environment physically, observing machines, equipment, chemical storage, emergency exits, safety signage, PP usage, working conditions at height. They take photographs. They take measurements. They can collect samples of potentially hazardous materials. They can conduct air quality monitoring. They can review maintenance records, training logs, and safety documents right there on the spot. And pay close attention to one crucial detail that few people know. The scope of the inspection can expand during the walk around. The inspector arrived because of a complaint about fall protection in a specific area. But on the way to that area, They pass through another section of the facility and notice an unlabeled chemical, an unguarded machine, and a worker using inadequate PP. What happens? They write it all down. Every violation identified along the route can become a citation, even if it had nothing to do with the original reason for the inspection. Meaning, you thought the problem was one thing. You just discovered it was 5. And during the walk around, the inspector also has the right to interview workers in private, without the manager present, without HR standing by, in private. And the worker has the right to speak, or to stay silent. But many speak. And what they say can confirm or completely contradict what the company presented in the opening conference. That training manual signed by every employee? The inspector can ask an operator directly how the lockout/tagout procedure works. If the operator hesitates, gets it wrong, or demonstrates they never received real training, that signed document just became evidence of a violation, not proof of compliance. Because signing without understanding is exactly the kind of inadequate training OSHA considers a violation. The third phase is the closing conference. The inspector presents the findings, points out the identified violations, discusses possible penalties, and gives the company the opportunity to present context, additional documentation, or immediate corrections already made during the inspection itself. This point matters. If the inspector identifies a violation and the company corrects it during the visit, the citation may still be issued, but the demonstration of good faith can reduce the fine. The American system recognizes the willingness to correct. It doesn't eliminate the punishment, but it softens it. Very different from ignoring the problem, which amplifies everything. And there is one final layer of this system that is rarely discussed outside the American legal world: follow-up inspections. After a company receives a citation and agrees to correct the violations within an established deadline, OSHA can come back, without warning, to verify that the correction was actually made. If it wasn't, the company doesn't simply receive a new fine. It receives a failure to abate violation, which accumulates $16,550 per day starting from the correction deadline. And now OSHA is no longer evaluating a potential risk. It is documenting a company that was warned, agreed to fix the problem, and chose not to fix it. This is the profile that sends companies straight into the severe violator enforcement program, and that puts individual managers in the crosshairs of the Department of Justice. 2,000 inspectors, 8 million employers, 130 million workers under federal jurisdiction. OSHA can't inspect everyone, but it doesn't need to, because workers file complaints. Accidents automatically trigger the system. And when the company finally appears on the radar, the inspection arrives with the full force of decades of standards built on top of real tragedies. Every form the inspector requests, every machine they photograph, every worker they interview in private is part of a machine designed to find exactly what the company never wanted found. And while we're talking about change, let's talk about hazard communication, the risk communication standard that ranked second on the most violated list in 2024, with 2,888 citations. This standard requires that every hazardous chemical in the workplace be identified with a complete label, have a safety data sheet accessible to any worker, and that employees be trained to understand the risks. Sounds simple. But violations are constant because many companies treat HazCom as bureaucracy, not as real protection. What they forget is that behind every symbol on that safety sheet there is a concrete risk: flammability, toxicity, explosivity, lung damage, nervous system damage. And if a worker doesn't know what they're dealing with, they can't protect themselves. That's the logic. Simple as that. Now you need to understand the American training system, because it is completely different from what most people imagine. In the United States, handing over a manual and asking the employee to sign it is not enough. The training must be clear, understandable, and appropriate for the worker. And here is an absolutely crucial detail: it must be delivered in the language the worker understands. If the company has Spanish-speaking employees, the training must be in Spanish. If someone only speaks Portuguese, the training must cover that. Throwing a technical English PDF at a worker who doesn't speak the language and calling it training is not just ineffective, it is a potential violation of federal law. And when OSHA inspects and finds that situation, they don't consider it good faith. They consider it a failure. And failure has a cost. But there is something that goes far beyond training rules and PP. There is a dimension of American workplace safety that most people never discuss: the financial impact across the entire corporate chain. Workplace accidents in the United States don't just affect the company directly involved. They affect insurers, who raise premiums. They affect investors, who monitor safety records as an ESG criterion. They affect business partners, who demand compliance certifications. They affect the company's ability to win government contracts, which frequently require a clean violation history. In other words, a single serious accident can create a chain reaction that affects the company for years. It is not an exaggeration to say that workplace safety in the United States is a strategic business issue, not merely a legal obligation. And now I'm going to tell you the most disturbing detail of this entire research. Do you know which sector leads in lockout/tagout violations? That standard that prevents workers from being caught inside machines during maintenance? The manufacturing industry. And do you know what the most common profile of companies that appear repeatedly on the violator list looks like? They're not disorganized startups. They are established companies with experienced managers who simply made the decision, consciously or not, to prioritize production over safety. The worker stops the machine for maintenance and the downtime costs money. So someone decides the full LOTO procedure is too slow. And then the accident happens. And then OSHA shows up. And then the lawyers show up. And then the Department of Justice shows up. And that few minutes of saved production time transforms into a criminal prosecution, a multimillion-dollar fine, and a national headline. Respiratory protection also deserves attention. Fourth on the most violated list in 2024, with 2,470 citations. In 2022, more than 22,100 cases of occupational respiratory illness were recorded in manufacturing alone, and another 2,000 in construction. Occupational respiratory diseases don't show up the day after the exposure. They show up years later, when the lung has already been irreversibly compromised. It's the kind of damage that no settlement can truly undo. And yet, inadequate respirators, non-existent or poorly implemented respiratory protection programs keep appearing year after year on OSHA's list. Because the respirator costs money. And because the damage appears too late for the employer to feel immediate pressure. Let me ask you a question that's going to stay with you. Do you know what a confined space is in the United States? Because there is an entire federal standard dedicated to this environment. And it exists because workers have already died suffocated, intoxicated by accumulated gases, buried, or trapped in spaces they couldn't escape. The rule requires specific entry permits, air quality testing before entry, constant external monitoring while someone is inside, and a rescue protocol that doesn't put the rescuer in danger as well. Every detail exists because someone died before it was created. That is the hidden pattern behind every American standard, real tragedies that became rules written in blood. And now, the final point that is going to close all of this in a way you won't forget. In the United States, the logic of workplace safety is not just moral, it is economic. Every rule created has a calculated cost for companies. But the cost of not complying is systematically higher. Daily fines, civil lawsuits, criminal prosecutions, lost contracts, increased insurance premiums, destroyed reputations, falling stock prices. The math is brutal and clear. Complying with the standards costs less than ignoring them. Always. Without exception. And yet, in 2024, there were 26,207 violations recorded in just the 10 most common categories. 26,000 situations in which someone made the wrong decision. So what does all of this mean for you? It means that if you work, manage people, or own a company in the United States, the system that was created to protect workers was also designed to be absolutely relentless with those who ignore it. And if you are a worker who didn't know your rights before watching this video, now you do. You can report. You can refuse. You can demand. And the law is on your side. If you made it this far, comment right now if you already knew about any of these rules, or never knew if this video opened your eyes. Because I need to know how many people watched all the way to the end. And because the people in the comments are the ones who actually want to understand how the world really works. Hit the like if this video surprised you. Subscribe to the channel if you want to keep receiving this kind of content that nobody else is making. Send this video to someone who works or owns a business, because this information can literally save lives and fortunes. See you in the next video. And trust me, the next one is going to be even more insane than this one.